Hello, everyone. Just gonna wait another 30 seconds as I see people are still connecting in and connecting to audio. Let's give them a moment. Okay, perfect. Hello, everyone. Welcome to the next session of our Women in Venture series that we've been doing here at Lowenstein Sandler. My name is Chandra, Shih, and I am a partner here in our Palo Alto office, doing work with emerging companies and folks in venture capital. I'm joined here today by several of my other partners and colleagues. We have Meredith Beuchaw and Alyssa Frederick, Julie Werner and Amy Schwind. The five of us today are really looking to give each of you some basic knowledge and background on common employment law issues that sort of every venture investor, founder, operator, or frankly, anyone sitting on a board of a startup company should really be thoughtful of and have a working knowledge of. And just for further background, this session is one of several sessions that we've done as part of our Women in VC series. Really, our goal here has been to share information with all of you, making sure that all of you are well equipped and well versed in some common topics that we see discussed. We've done past sessions on negotiating term sheets, things to be thoughtful of in exit scenarios, tax considerations in various transactions that might be of interest, and also some compensation and benefits issues. And so today, Julie and Amy are two of our resident experts in the employment space, and we're really going to enjoy learning from them about some of the common issues that we think you all should be aware of. So Julie and Amy, I will hand it over to you and let you two dive in.
Okay, great. Yeah, so we're happy to be here. Amy and I are both in our employment practice group, and our practice involves primarily counseling, but also litigating when necessary. Obviously, the goal, I'm sure for everyone on this call, is to avoid the litigation. And so, yeah, Amy's, I guess, sharing the screen here. So generally speaking, I guess just to go to the next slide 2, these are topics that I'm sure you can imagine if we had the opportunity, we could talk about any one of these for a very extended period of time. From our standpoint, though, for purposes of today, really what we're trying to do, to Chandra's point, is more of an issue spotting, things for you to generally be aware of and how it may impact you both, again, whether you're an investor or on a board or as an operator of a business. And so generally speaking, onboarding, bringing people on, what the documentation should look like, and general issues. Again, all of this is under US law. What worker classification issues sometimes come into play, especially in the startup space. It's extremely common to see people early on classifying people as independent contractors, whether or not that should be the case, as well as treating them automatically as exempt, salary exempt, even if potentially they should be non-exempt. Talk about harassment and discrimination issues, as well as work from home considerations, particularly in the past few years. And then finally, some general hiring trends in terms of salary transparency laws. And AI, of course, is the hot buzz topic of the day. And there are some employment considerations in the AI front as well that we'll talk about. Next slide. So generally speaking, oftentimes the first step is, so you, again, all different frameworks, but let's assume, right, you're a founder, you started a business, and you are bringing on your first person. And the question is, what should the documentation look like? Does not have to be complicated by any means, but clearly once you start paying, or I should back up, or should be paying, that is when somebody is working and providing services to you and generally is not an owner of at least 20% of the business. So as a technical matter, generally, they're, under federal law, that if somebody owns at least 20% of a business, generally speaking, they don't necessarily need to be paid because they have an ownership interest, right? If I establish a lemonade stand tomorrow, it doesn't mean automatically I could start paying myself. But at some point, once you start bringing people on and you have to start paying them, being clear in writing about what that looks like, how they're being paid. Super important to be clear that employment is at will. We oftentimes see people sort of get caught up in traps where they're working with other, again, what I'll call friends or people they've met in different spaces, or two people are in business school together or whatever, and they decide to create a business. And then later on, somebody comes back and says, oh, I should have gotten this, and why didn't I get paid? And you can't fire me, and all those kinds of details that I'm sure my tech colleague partners here, we've all run into from our standpoint. You guys all call our group when those kinds of founder disputes and other things arise, that again, with the hindsight of 2020, we would say, look, it would have been ideal if those things had been spelled out up front. So ideally,
just to double down on that, Julie, I think there are a few inflection points where we really care about it and see it come up. One is certainly when something goes wrong, right? And then you've got the person claiming that they're entitled to something more, or the relationship's just not as good as it was originally. And it's virtually impossible to get people to agree to something favorable for the company at that point if the relationship soured. The other place we see it come up often is in due diligence, when you are doing your sort of next financing round, or maybe you're on the investor side and your counsel is doing diligence on a potential target, and having your financing transaction get held up because of some issue like this is never fun. And it's oftentimes hard to chase people, especially if they're sort of no longer with the company or may not have a huge incentive to sign stuff that you need. So, the time at which it's easiest to get people to sign stuff is when they're excited about coming to work with you and help you. And so just making sure you've got it buttoned up at that point can save you tons of time, effort, heartache, and expense later, frankly.
That's right.
I would just, I'm Alyssa, Frederick. My practice is similar to Chandra's. I work with a lot of startups and venture investors. And I would just add that it's actually close to incorporation where some of these issues come up that are trickiest. And then that's partly because often equity is promised at that stage, and sometimes really substantial equity stakes. And so we really recommend letting your lawyer take a look at any promise that you make as a founder to someone else for equity in the company, because of course the ownership of the company and having a clean cap table is probably the most important legal thing from my perspective to set up early on, and not have a claim for more equity than you want to have given.
So +1, as all the corporate lawyers pile on from the M&A perspective, this comes up all the time. People are promised equity on napkins, like in Facebook, it really happens. But the other thing is the invention assignment agreements, like try to sell your company. If you don't have those, you will be chasing people down and having to pay them money who haven't worked at your company in years. So please do get those in place and make sure that folks who are signing them can sign them. So one common trap I see working with tech companies is having a professor be a part of your IP creation and not really understanding what the professor's contract is with their university, and if they've already assigned their work to someone who's not you. So good question to ask.
Absolutely. Yeah. See, we see all these things, I guess, especially from our perspective, right? After the fact, when all the cleanup and all these issues arise. So being proactive, obviously, in thinking about them. Again, going back to the notion of being clear about what the compensation is, what the terms are, the fact that employment is at will, being clear, as Meredith said, about assignment of inventions upfront, confidential information, putting aside even the issue of non-competes, which obviously vary significantly by state, and the law continues to be in flux just generally on that. But those basic terms obviously should be communicated up front. There are other things increasingly in terms of various state laws where we often see, so even, for example, getting workers' comp. People oftentimes say, I'm not a factory, what do I need workers' comp for? As soon as you have employees, these are laws. So buying workers' comp itself is very inexpensive. Getting a notice from the state saying, why don't you have workers' comp? And we're charging you $10,000 a day for whatever it may be for all your penalties and this and that, gets to be a lot more expensive. So buying the policy up front, and candidly, increasing, especially with startups, we see people working with the PEOs like the JustWorks and TriNet and Sequoia, et cetera. There are a million reasons to do that. And frankly, among them is just not having to think about a lot of this stuff, because that clearly falls under the umbrella typically of the PEO. I'm not here endorsing anyone over the other, but like Gusto, as I understand it, is different because I don't know that Gusto does all that stuff, where I think a bunch of the more actual PEOs will do those things. So disability, taking out disability insurance and paid family leave insurance, increasingly common in many states. All that kind of stuff has to be done. New York, for example, has mandatory annual sexual harassment training, mandatory policies, and all this stuff. And we'll talk about the harassment and discrimination piece later. All this is the stuff that it doesn't matter until it matters. And then once it matters, you go, oh my gosh, why, coulda, shoulda, woulda done a bunch of these things. Somebody in the chat asked, wage theft notices of various states, including New York, California, a bunch of other states require that you communicate upfront whether an employee is exempt or non-exempt. And Amy will explain more what that means. And so one of the ways that gets communicated is through a formal notice that's required. It's a form basically by these states. They have scary names. They call it Wage Theft Prevention Act because it makes you scared like you're a criminal or something, but that's technically the name of these laws. Immigration, I-9 forms, making sure that your people are legally authorized to work in the United States. And again, these are all the things that it doesn't matter until it does. Or as Chandra, I think, was saying earlier, somebody with respect to diligence, right? Like you're going to have to, at some point when you're raising money, make representations that you're in compliance and a whole bunch of these things. And if you're not, as I'm sure these guys would attest, it obviously becomes challenging to have to clean up a lot of that stuff. One last point before we move on to the next slide, and that relates to commission plans. So it's obviously not often your first employee, but hopefully relatively early on, you're in a position of thinking about sales and incentivizing people through commission plans or compensation other than just a flat salary. Being really clear in writing about what has to happen for a commission to be considered earned is extremely important. And whoever used the expression of the back of an envelope or a napkin or whatever, I've seen a fair amount of commission plans that try to sort of fall under that umbrella, and that stuff never works. Every inference is against you as the company and is going to be in favor of the employee. So those are things where just a little bit of upfront planning will ultimately help you in the long run. Next slide. Oh, and just the notion we were talking about NDIAs. So generally speaking, yeah, the notion that non-competes will vary significantly by state, and being really clear, not everybody loves a one size fits all. Everybody loves to use just the sort of generic boilerplate agreement. A number of states will not allow non-competes, as we know, California among them, but increasingly a bunch of states have salary thresholds, have other restrictions or limitations on non-competes. There's a bill that actually passed the state Senate in New York that we're following very closely that if the assembly follows, will ban non-competes in New York, which is just a crazy idea in the extreme. We're following that closely, but just to be aware, there are really significant changes and distinctions based on state. Next slide. So Amy, as I mentioned earlier, this goes to this issue of being clear up front about how the person is being hired and what that all means. Amy will share some more on that.
Yeah, so one of the issues that we routinely see, and a lot of times it comes up in the corporate context and the employment diligence of companies that we wanted to highlight, is worker classification and misclassification and the difference between employees and independent contractors. So here are some practical differences between them. I won't go through all of it point by point, but essentially, employees, we have people, they need to be paid cash wages. And as Julie mentioned, equity is generally not acceptable as the only form of pay. And we'll go into that more a little later on as well. For independent contractors, compensation is generally a matter of contract, and equity might be an acceptable form of compensation. And then we have a lot of other employee related laws that we have to comply with, wage and hours. So employees must receive at least state and federal minimum wage. They may, under the state law, be entitled to meal and rest breaks or overtime pay if they're non-exempt employees. They may be entitled to participate in the employer benefit plans. And also many states have mandatory benefits that have to be provided to employees, like paid sick leave, paid family leave, as Julie mentioned, workers' compensation, unemployment insurance. And typically these are not things that generally might be required for independent contractors. Sort of the chief distinction in terms of, so there's many different factored tests that can apply, and it depends which state you're in and actually which law you're assessing under, whether it's the tax laws, the unemployment laws, the wage and hour laws. But what it ultimately boils down to under these multi-factor tests is control, and employers have control over employees, and they should not be exercising control over independent contractors. And so what these multi-factor legal tests, look to is indicia of control. Employment might be at will for employees. And then for independent contractors, typically it's a term under the contract, and there are certain, provisions related to termination of the engagement. Employees can be subject to restrictive covenants. And then generally independent contractors, while you're going to want to have them bound by confidentiality obligations, invention assignment, typically things like non-competes are not something that would be, proper for an independent contractor, because it is an indicia of control. Anyway, so things that we typically hear. So I pay them by 1099. Okay, but that still might not be proper. They perhaps should be paid by, W-2 and be an employee. They want to be an independent contractor. It's their preference. Here again, it doesn't boil down to preference in the end from a legal standpoint.
So, yeah, I mean, we typically hear, this person, I can't tell you how many times we've heard this expression. They're a W-2 independent contractor, or they're a 1099 employee. That's an inconsistency between the two.
Right. So ultimately it is a legal test here. Chandra, are you switching the slides?
Yep, I'm happy to.
Okay.
Yeah, get to page 5, Chandra.
Oh, page 5. All right.
Yes. But this notion even just of somebody going, oh, they're a freelancer, or oh, they're a contractor. Like, there's two kinds of things you could be. You can be an employee, or you can be an independent contractor. Like, those are the two things, right? Like, and all these other phrases are phrases that don't really actually have any legal consequence, right, Amy? Like this notion of being a freelancer, what does that mean and all?
Right. And so in terms of consequences for not doing it properly here, we do have it. I'm still not seeing the slides.
Oh, it's still not showing?
Okay.
Let's
No.
see.
No.
Let me swap. How's that? Not working?
No, but Amy, why don't we just keep going, right? So what are the misclassification risks? What are the potential consequences?
Right. So there could be liability under wage and hour law, individual or class action claims for unpaid wages or overtime, meal and rest breaks. There could be liquidated and statutory damages. There could be prejudgment interest or attorney's fees, tax liability and penalties, payroll taxes, Social Security and FICA. There can be, as Julie mentioned earlier on, significant fines for failure to maintain workers' compensation insurance, unemployment insurance, and disability coverage. There can be civil fines, criminal penalties. Those are more unlikely, but they are in the statutes and they are scary.
One of the things I was just going to add is sometimes I see this come up in the most innocuous of ways. Somebody's an independent contractor. They've worked for you for however long. They leave, they go to apply for unemployment, whether they're doing it intentionally or they just think that now they're entitled to unemployment. And unemployment says, who are you? We have no record of you. We've never taken out taxes. And that's what prompts this thing to come to a head. Not that they were threatening to sue you or being super aggressive or adversarial in any way. It comes up in very innocuous ways. Right. So, and from my tech partner colleagues, right? So how do you guys see it come up in the deal context?
We often will see situations, especially for early companies, where everyone's just been set up as a contractor and where, the financing round and the diligence process becomes an inflection point at which people are asked to make adjustments and move people over to being employees. From a risk perspective, certainly, the expectation is the company sort of bearing the risk for the stuff that they did before and is likely giving a clean rep as to things around employment and compliance with it. And then you're asking folks to move over. And so it's about getting your ducks in a row at that point. Certainly similar issues, I'm sure, on the M&A side at an exit.
Yeah, I mean,
That's
Meredith,
right.
I was just to say Meredith, I mean, sometimes they can affect the purchase price, I imagine.
That's right. So if a buyer finds these issues, they may ask for a reduction to purchase price. They will certainly ask for a specific indemnity if they're hit with losses after the deal. There is a full expectation that a selling company's shareholders will bear this risk and a buyer should not be asked to inherit it. It is one of the most common specific indemnities and diligence findings when younger companies are sold. It can be pretty straightforward, right? It's simply economic, you bear the risk. And the buyer will say these are going to be employees after the deal. Pretty straightforward for employees in the US. Definitely gets more complicated if you have contractors overseas who should not have been contractors. And all of a sudden the buyer is in a position of learning those local labor laws, figuring out if they need to set up new entities. I've seen that slow down deals. So it is important when you have people overseas to make sure that everything is proper there, because that can be a real drag.
I think we're ready to move to page 7, please.
Yeah, slide 7.
Right.
Okay, so there's the employee versus the independent contractor classification. And then if we have an employee, there's the classification of exempt versus non-exempt. And so unless an employee falls into a minimum wage or overtime exemption under federal law, so the Fair Labor Standards Act, and applicable state law, the employee must be paid at least minimum wage for all hours worked, and they must be paid overtime for all overtime hours worked. And it's important with non-exempt employees to be tracking their time, because if a claim that somebody worked overtime came in, we need to know, what hours were they working. And so there are different ways that it can be kept. They can keep it, you can keep it, but it needs to be tracked and those records need to be preserved. And also important to note that overtime has to be paid if it's worked. So even if there's a policy that employees are not entitled to work overtime, if they work it and if they violate that policy, there can be repercussions, but the repercussion can't be that we're not going to pay them the overtime. So it is, if they work it, they need to be paid it. Can we go to the next slide?
So somebody had asked a question about if there's more than one co-founder. I mean, ultimately it goes to this issue. I think you can generally think about whether or not somebody has a 20% ownership interest or more. And that's not, I mean, look, so that is true under the federal law. Whether or not states will 100% honor that is a little dicey, although candidly, I don't think we've ever really seen an issue in that regard. Again, just because I open a lemonade stand tomorrow doesn't mean all of a sudden I can afford to pay myself all this money. Or if Amy and I open it together and we each own 50% or 50 or 60-40 or whatever, that still doesn't mean. But once we start bringing other people on to a point that somebody does not have an ownership interest of at least 20%, you need to be in a position either that the person is working not at a level that makes them an employee, meaning they're an independent contractor and you can satisfy that test, in which case you can pay them whatever is negotiated, whatever that amount may be, cash, equity, something else. But otherwise, and this is where it comes as a surprise to people, but like otherwise you really need to be paying them at least minimum wage. And people go like, it's like an insult. I hate to say it like that, but like as if, you're working at a fast food place or whatever. But the reality is they have to be paid at least that amount if they're not actually an owner of the company, or if they don't meet the test or standard to be an independent contractor. All of this, and look, we're not naive, like we're telling you what the law is. We recognize not everybody follows all this stuff, right? And so we realize like what we're saying doesn't necessarily always comport with reality, but I go back again to it's all good until it's not. And when it's not, and you have to clean up some of this stuff, it's like you'd wish, if I could have just paid that person $15 an hour, obviously it would have been a lot easier.
Right. As an example of that, I can recall within the past year, having an issue, a startup. It was somebody who had been the CEO, sort of was ousted, things soured. And this was, they were in California, and a demand letter came in because that person during her time there, even as a very senior person, she didn't meet the bona fide 20% equity interest. So, and she was not being paid at least minimum wage an hour. She didn't have payment for a while other than equity, but she didn't meet this test. And a demand letter came in from her attorney, alleging many different violations under the California wage and hour law. And so, it had to be resolved, obviously, and it was resolved before actual litigation. But that is, a real world example of how this does get raised and it can get messy. So there are, to classify as exempt, the employee has to pass the federal and state duties and salary tests. So the most common duties tests that we hear about, they're called white collar exemptions, executive, administrative, and professional. And there are different tests under the federal and state law. Some of the states vary from the federal or very slightly as to how to achieve those duties exemptions. There's something called the highly compensated employee exemption, and there's it's less duties that need to be satisfied, but there is a certain salary threshold that we'll go through on the next page for that one. We've gone through business owners, and then there are certain other exemptions, like for salespeople, computer employees, and so those are sort of specialized exemptions. And it is important to see if the exemption is recognized both federally and then under state law, because sometimes the state law can vary. And so we need to be checking the boxes under both to ensure we're compliant. Can we go to the next slide? So here are some salary thresholds. So if we've achieved the duties part of it, the other half is salary. And so for white collar exemptions, there's a somewhat low federal level. It's a little over 35,000. But there are higher thresholds for certain states and localities, actually. So New York City, it's significantly higher at over $58,000. And then California, in the state, it's even higher than that. So it's over $64,000.
So Amy, just to keep moving to the next slide, so we're good on time. I think just the takeaway on this is that if you don't have the money to be paying salaries at these rates, then you need to be making sure then that these people are being paid at least minimum wage and they're being tracking their time, and or that they meet a test to be an independent contractor. And I think on slide 10, we've already identified what some of the risks and things are. So maybe we can move to slide 11 just to get now to another topic that we have here. So obviously in the past 5 years or so, this is increasingly taken on more attention, the whole notion. And from a board, I think this was the type of thing historically that boards maybe were looking at with one eye, and now we're looking at more closely with two eyes in terms of all the issues that can arise. And when we think about, again, obviously, hopefully most of us are evolved enough not to be, thinking about these, like, I always hate to say it in this way, but I always go, where are these people? Like, who are their mothers? Like, who raised these people to behave this way, to speak this way, to think they can treat people this way? But obviously this stuff still goes on. There's lots of bad behavior. We'd like to think and hope that people have improved. But instead of just thinking of it on a one-off basis, I think we can all see now at a more global level, and you see a lot more, and certainly at the public company level, there's a lot more attention being paid to these things in terms of corporate governance and things like that. But just even how, directors just in and of themselves can have certain fiduciary duties to be aware and familiar with what's going on and what their own actions can be and how those things all get attributed to the company. There's always a story that's going on in the Wall Street Journal or wherever else that we're reading. And it always amazes me, again, given, where we are, that this stuff still happens, but it does. I don't know whether or not Meredith or Alyssa, anybody wants to sort of, from your vantage point, how you see this, even in terms of reps. I'm assuming you guys have seen, I know, especially, right after the heightened Me Too, we saw a change even in reps being included in deal documents, right?
Yeah, definitely. And I think a lot of early stage investors now require companies to have anti-harassment policies. That's something that I recommend startups do anyway. It can be part of your employee policy, and we, whoever your lawyers are can help you put one of those together. But I definitely see more reps and covenants that investors are asking for on this topic. And I think it's just something when you're in the boardroom to be aware of. If a matter is discussed, you may have a duty to, as a director, work with a company to make sure it's handled properly and investigate.
Aren't audit committees often involved, Meredith, in these kinds of things too?
Sometimes. And Julie, I know you and I have worked together and had this, nearly derail M&A deals when things like this happen. So it's really important that as soon as anything is brought to a board member's attention, that you bring in outside counsel. You probably want to do an internal investigation to figure out what's happening. You want your hands as clean as possible, that you did the right thing as soon as you had any reason to know about it. And this happens frequently. It is one of the most common topics that investors ask us to talk to them about, and one of the least common topics that founders ask us to talk about. But it's not necessarily the founder who's causing the problem. It is the founder's job, though, to bring it to board members' attention if they know that something's happening.
And Julie, don't you also think maybe just a second on insurance considerations when this kind of stuff happens?
So increasingly, that is definitely true. And so what's called EPL, Employment Practice Liability Insurance, is extremely common for companies to have. And I go back even to that example, buying a workers' comp policy early on, which A, is required, but B, is the kind of thing that after the fact, when you didn't have it, the penalties and all the things for not having it are much worse than, whatever the dollar amount. Likewise, having EPL, Employment Practice Liability Insurance, which sometimes is a standalone policy, but sometimes we also see is attendant to directors and officers, a DNO policy. I don't know enough about exactly how it works, but sometimes I feel like they throw it on as a an added perk to the D&O, and maybe it depends on what other sort of bigger scale insurance there is. And I'm sure that's another topic for you guys could have a whole session on types of insurance that people should think about. But EPL is the type of thing where when you have it and an issue comes up, you're really glad that you have it, and you put the carrier on notice. You have your deductible for the most part, likely it's expected to be covered. And then that you've got limited exposure. Now, look, that may be in terms of the financial risk. Obviously, there's PR and other considerations in terms of, when companies are going through these issues, we see reputationally there can be significant impact on a business. Lots of companies, have really struggled in terms of press and PR and all these kinds of things. And so obviously being mindful, but the insurance is sort of one of those pieces, at least to have at least some peace of mind from a financial standpoint that the damage can be contained.
One other note here for managers and directors. So there is this complex patchwork of employment laws at the federal and state level that cover these issues. And so if there's a claim, it is really important to bring in outside counsel. But then also when there are discussions about any litigation or potential litigation matter at the board level, it's also important to have to make sure that you have a lawyer, the company's counsel in the room, and that you're preserving privilege, that those certain conversations related to the litigation are just among the directors and officers of the company, not board observers or people who don't have that status.
So, and what do you guys see in terms of even meeting minutes, or what should be reflected in minutes or not be reflected? And what's your thought on that, Alyssa?
Yeah, I mean, so I see the purpose of minutes as preserving a record in the event of potential, usually corporate litigation, that the board was fully exercising its fiduciary duties in being diligent. And so in minutes, we always want to note that the board brought in outside counsel, brought in whatever consultants they needed on any matter to do diligence and make them, be fully informed to make the best decision. But we don't want to include details that, anyone reading the minutes, who will likely include, potential investors in the future, potential acquirers. We don't want really confidential details there that could destroy privilege or that shouldn't be disclosed to others outside the company.
Right. Or even when founders, oftentimes when I am initially involved with these things and the companies are, getting just a letter or some kind of demand or threat or things. And often the discussion is, well, do I tell my board? When do I tell my board? How? And people, and this is just a broader observation, start drafting emails and text messages and all these things, because obviously there's efficiency, but it's not necessarily privileged. So you want to make sure that you're alerting your board to these things, but you have to be mindful of the written record. And especially if it's not, and again, to your point about making sure lawyers are copied either on emails or are involved in the communications, because privilege becomes an issue. If in the worst case scenario, there's litigation, all of those things would be discoverable.
And Julie, we've got a couple questions in the chat that might be worth talking about. One was just, generally when we're thinking about employment matters, the question was, are we basing things on where the company's headquartered, or should it be the employee's home state when we're thinking about exemptions or rules to follow?
Sure. So that would be based generally on where the worker is based. And I say that subject to the caveat that if I am a worker in, Idaho, Wyoming, or whatever, and I'm working for a company that's based in California, you can assume that I'm going to be looking for the rights and benefits and protections under California, because obviously they're likely to be more favorable. But generally speaking, it really should be based on where the person is actually physically working. And, sometimes there's considerations there in terms of payroll taxes being taken out and, which is which is the company required to do business or is qualified to do business in other states. And Alyssa, you had a point, I think it was the other day, about California in that regard. I think, Alyssa, that was you, right?
Oh, that was me.
Chandra. Yeah.
Different states have different requirements with respect to whether you need to qualify your corporation there as what we would call sort of a foreign corporation. We're assuming here most companies that we're thinking of are Delaware C corporations, because that's typically the type of entity that venture investors are interested in investing in and strategic investors. And if you've got folks located in California, or you've got a distributed workforce all across the US, different states have different requirements with respect to whether or not you need to actually register with their Secretary of State and their franchise tax board. And California is an interesting one because they actually require you, if you are paying salary or have payroll obligations in excess of a certain dollar amount, and that dollar amount is, I think, somewhere around $60,000. So typically for California-based employees, really, if you've got like 1 or 2 employees there, you probably will need to qualify in California. Same as everything else we're talking about. There are varying degrees of compliance with that type of a thing. And, it's a matter of determining, whether it's worth doing it at this point and what the risk is. And those are things that, your counsel can work you through. But it is important to keep that in mind as well. And that is separate than registering as an employer in the state with like the EDD or other organizations.
Right. One last point on the discrimination harassment before we move on. Just as I said before, obviously it's best practice to have a policy, but as I said, New York mandates that you do annual training. New York mandates that you have a policy. New York actually has very precise language that's required in your policy. So just even having a policy that says we prohibit discrimination or harassment is not enough. New York has very specific requirements in terms of what's needed. And so just to think about again, and this is always the challenge, and I think moving on to our next topic, work from home considerations is actually relevant here because as Chandra was starting to say, in terms of having a distributed workforce, there's various consequences, and Amy can speak to that.
Yeah, so I don't think this slide would probably not be in here if we were giving this 3.5 years ago, but now, post-COVID world, companies have employees, lots of different places that they didn't have employees before. And as has just been mentioned, the employment laws in the states, they're not one size fits all. So there may be, new requirements, new benefits that the employer has to be aware of. There might be, you should consider the application of the FMLA. So there are rules on remote workers for that. Employee handbooks, where are you located? What laws does your handbook have? And then, should you be doing addenda because employees are potentially, covered by other laws and have, other rights that they should be informed about. Insurance issues, we talked about the workers' comp disability, reporting the employee to the state for new hires. Also, expense reimbursement is something to be aware of. So California and Illinois have statutes that mandate expense reimbursement for employees. So if employees are located in areas where it's mandated, that might differ from your policy. So that's something to be aware of. And many employers are instituting or have instituted work from home policies to address some of the issues that may arise, given that employees are scattered and working in the remote context. Tax considerations, you should speak to an accountant and payroll provider to see, what are the obligations there. And I think registration to do business was just covered, but it really, having a workforce that is diverse geographically, it really does, open up new doors in the employment law sense, and definitely need to be aware that as the employer, you might be subject to additional obligations.
We're also seeing this come up in other contexts. So a really simple example is a lot of companies nowadays use Carta as their CAP management platform. And one of the things that Carta is requiring companies to do is verify and keep up-to-date records on locations for option recipients and folks who are receiving equity awards, because part of what CARTA will do is when those folks exercise options, they'll help you try to figure out what the withholding obligation is with respect to the option that's being exercised. And they are making companies confirm and provide address information. And so just little things like that, it can just be so important to keep your roster up to date, make sure you know where people are, and you're getting asked to confirm that across the board in ways you might not have normally expected.
Yeah, I was going to say, I think early on in COVID, everybody was just obviously trying to stay afloat. But at some point, right, people were moving and they didn't even tell you that they were moving. You didn't know where they were. You have this work from anywhere type of thing. Oh, go live on an island, go do here, there, and the other. But I do think it is starting to catch up, as you're saying. Obviously, CARTA is, I think that's a great concrete example of where, how with the payroll withholdings. But just in general, I think, you know, again, we all had a little bit of breathing room and a little bit of a reprieve, probably for the first year, even or two of that. But now I think we have a lot of companies that will say, we don't want to have, like they ask us, like, are we discriminating if we don't want to hire or have anybody working in California, for example, or certain states? And you can make that business judgment. I mean, look, you're counting on these people to be honest and truthful with you. And so there's always that. But yeah, I mean, some companies choose to, you know, limit where they're going to have people based on some of these consequences. Next slide. So another area that, just to be mindful of big picture, is this notion of what's called salary transparency. So historically, right, companies would just say, we can pay whatever we want to pay people. It's a negotiation between the company and the employee. But the public policy around these laws generally requiring companies to post a salary range is that it improves the ability, you know, again, historically for women or other disadvantaged groups historically to have leverage in terms of negotiation, because oftentimes, especially, you know, many studies will say, like, what your first compensation is sort of continues to track throughout your career. And so when you start lower early on, it obviously can continue to follow. So companies in many states now, including New York and California, just, you can't even ask, you know, you're interviewing somebody for a job and saying, like, what did you make at your last job? Things that people would historically ask about, you're not allowed to ask anymore. You can ask, what are you looking for? Right. So, I mean, that's certainly permissible. But if you are posting job ads on LinkedIn, social media, any kind of internet, job post, job board, intranet, etc., you need to list in many states, New York, California, increasingly a number of jurisdictions, a salary range, and it's a good faith range. So I'm sure many of you have seen the articles. It's kind of funny. I think the first day, right? So in New York, for example, November 1st, everybody on October 31st was freaking out. How are we going to comply? And how do we know what the good faith salary range? But then shortly after, I saw job posts or people writing articles, you know, the range for this position is between 100 and 500 or something like crazy. And they were just sort of mocking, like, how could that be a good faith range? I don't know that it is or it's not. I mean, these laws are still very new, so it's still soon to say. I don't really think that they've been tested, or I'm not aware of any litigation, or certainly no court opinions that have really definitively ruled on that. But it is this notion of, quote, good faith in terms of having a good faith range. While New York only requires the actual salary, a number of other states require that you are more comprehensive in listing. And candidly, if you're going to try to recruit, I don't know why you would just list salary. If you could say, we offer bonuses, we offer health insurance, we offer, even, you don't have to be super specific, but listing categorically other types of compensation. So just big picture to be aware. And I think this also just sort of ties into DEI considerations, which also increasingly, I think companies and boards, et cetera, are paying attention to in terms of just having a commitment to trying to have a more open and inclusive sense of communicating about various aspects of employment. This is another area, obviously, just in terms of compensation. So knowing that these laws exist in various states, I think is important. Some people have been paying attention, others not yet as much. And I think it's a trend that will, as we see how it plays out in practice, including the potential for litigation, we'll get more clarity around what, quote, a good faith range means. If you want to move to the next slide, I think Amy's going to also talk about the idea of AI, which is coming up and including legislation that has passed and about to become effective in New York.
Yeah, so we wanted to touch upon this because it is a hot button issue in the employment world. Lots of articles about it in the news. So there are at least 16 states, including California, that have introduced bills or resolutions that relate to AI and employment. And the federal EEOC has actually undertaken an initiative focusing on AI and using it in hiring and employment decisions, and whether, and how that complies with federal anti-discrimination laws. In New York City at the local level, there is a new law that was postponed, but it's set to become effective July 5th of this year, that limits the ability of employers to use AI in their employment decision tools. And so there's a very technical definition of what qualifies as an automated employment decision tool under that law, and there are regulations that go into even further detail and technical specification. But an example of this would be if an employer is buying software that is going to help them sort through resumes, classifying people as highly qualified for the job, moderately qualified, not qualified, or ranking them, giving them some sort of score. And it is the computer algorithm doing this. That would be a covered AADT, and it would be a covered process by this law if they're using it in hiring, or if they're using a tool for promotion. And so there are certain requirements that the employer would have to follow, including conducting a bias audit on the tool if more than a year has gone by since the last bias audit. And that audit needs to be done, it needs to be an impartial evaluation by an independent auditor. And so there are firms cropping up in this independent audit space. So I think it's going to, lead to this industry that is conducting these audits, because it can't be the employer themselves and it can't be the developer of the actual tool. So a bias audit needs to be conducted. They need to publicize certain information on the website and then give certain notice to candidates and employees. So just wanted to raise it because it has been in the news quite a bit that there is this requirement in New York City, and to be aware of it if you are or are considering using any of these tools in your hiring or promotional process.
There was a question that just came up in the chat that I'm not sure I'm totally following. If the question is, can you sort of Google people and look people up on social media? Obviously, that's very common these days. I'm not sure how AI in particular relates to that, but certainly it's common, and we see people Googling people. The whole issue, I think, relates to you can't refuse to hire somebody on discriminatory grounds, and there are limitations in general in terms of somebody's conviction or arrests and things like that. So you have to be careful. On the one hand, we obviously have so much access now to information that we've never had before. So on the one hand, you almost feel like you would be derelict not to be exploring and then making sure you're aware of the information out there. You don't want to be the one person who doesn't know this guy's like a serial killer. And if you had only Googled the guy, you would have known. On the flip side, there are, as you can imagine, general rules and protections in place, certainly in terms of doing formal background checks. But if you're Googling, I always just at least say, be consistent in your Google. You don't want to be doing it for some, not others. You don't want to be in the situation where you see somebody was in a 5K for like a breast cancer run, and then you say, oh, I don't want to hire this person because, oh, they're a breast cancer survivor, and I don't want to worry that I'm going to hire them and they're going to have a recurrence of breast cancer, for example. So it's that whole thing, like, be careful with what you're doing with the information, or at a minimum, certainly how you're vocalizing or articulating what you're doing with that information. And I think with AI, in general, this is obviously, as Amy's saying, a law that is new and is still going to be playing out in real time, but it's something I think everybody's paying attention to, not just in terms of this law, but I can't tell you how many companies have contacted us and they go, we want an AI policy. And I go, okay, what is it you want it to say? Do you want to allow chat GPT? Do you not want to allow? Oh, I don't know. And I go, oh, okay, well, let's like figure out what you're actually trying to accomplish. And I don't know, Chandra, you're laughing. I feel like you've probably seen some of this stuff too.
No, I am. It's very true. And I think one of the wonderful things about the accessibility of a lot of the generative AI models that have been, made public lately is that we are seeing a huge surge in people looking for interesting and creative ways to leverage those tools. And we're seeing companies start up that are, thinking about ways to leverage or maximize benefit for those. And I think it's going to make a lot of AI applicability a lot more cost efficient and available to people who might not otherwise have been able to afford some of the AI solutions that were around previously. So I think it'll be interesting and great, but we're all going to be figuring out together what things like the right AI policy looks like, and also, frankly, reacting to legislation, which is notoriously bad at keeping up with new technology. So I think it's a little bit of a wait and see space. But it should be interesting. And I agree with Julie, consistency is key with some of the stuff you're doing. You just don't want to treat people differently when you're thinking about hiring decisions. And I think that's an important factor when you're looking at things on social media or when you are using AI tools or other stuff. And, routinely auditing what your practices are makes sense, whether you're leveraging AI or not. And so I think that's an important takeaway also.
Hey, I want to be mindful of time. I know folks, including folks on this call, have 3:00 Eastern appointments. Thank you, everyone, for joining us today. Julie and Amy, thank you. I learned a lot today. We haven't gotten to all of the questions. We've gotten to many. We are happy to connect individually after this. If you want slides, please reach out. And thanks for joining us.
Thanks, everyone.
Thank you all. Bye.